Apart from the disrespect to the nominee, it even went further to affect another justice, the most senior justice of the day, Justice Puamang, who was the chairman of the committee that recommended that the Chief Justice be removed. To some extent, I would blame Justice Puamang, because as I have said, I think I've said here or somewhere, that his own report is the problem. The minority leader was one of the reasons why I petitioned, my client petitioned for the removal of the Chief Justice. There was a huge count which mentioned his name and mentioned the acts that formed the basis of our petition. What was this count? We said he had set a precedent, in fact, a record in the court by being the only party or being the only person who within 2 hours was able to get a full panel of the Supreme Court presided over by the erstwhile Chief Justice to give him orders that by the scope of the application before the court, no court in the world, in the common law jurisdiction, will give him. Now, in the course of all of those proceedings and after, people who knew the two of them spoke to me and they said, don't you understand? That is his sister. The removed Chief Justice is his sister.
Sister in terms of
they come from the same place.
Okay.
1, 2, when her father died, the minority leader hosted her visitors, and people who were there called me. So in if I had attended the next proceedings, the next person against whom I was going to raise that objection was the Chief Justice. I said, all of these arguments we are having back and forth, and you are literally descending into the arena of conflict, is because somebody that you are close to is the plaintiff in this particular matter. Who was the plaintiff? It is Afenyo Markin. 2, there is now information coming out that there are services being rendered in the judicial service which are linked to Afenyo Markin. He's rendering those services and getting commercial profits from them, and huge ones. And so at this point in time, when Afenyo Markin is making it look like, okay, there's a national public interest aspect of all of this nomination process, and there's some dispute and all of that, it has nothing to do with a minority position. He sold it out to his colleagues to believe that, well, we all have to take a collective position against this, but it is a personal interest. And so the facts that we have show that you have an interest in her being there. And so he's crying louder than every other person because he has an interest in the woman being there. I think they should look at this whole idea of prior approval. That the Constitution didn't say vetting. It said prior approval of Parliament. There ought to be another way of, when they look at your CV and they've done your background checks, if they are calling you for any vetting, then there are specific areas they want you to clarify. Otherwise, Parliament should do an acclamation and you go. And then if you go and you can't deliver, your appointer is there, he will sack you. Yeah. But they keep all of us glued to television. And we are sitting down there and watching a process that 95% of is a joke. If the AG says he wants a docket now, and you can have an excuse, and the AG is getting jittery, you can understand that you have even told Ghanaians that way back you tried to stop the man because you had reasons to stop him. 1 year into a regime, you are still investigating. So what is the basis for seeking to stop him previously? And the Constitution is very clear. Some people even still think that his position is untenable in view of the Constitution. But there's a small provision in it that I understand. In his enabling enactment, it is stated clearly that he can prosecute on the authorization of the AG. So how can it be then that he's on equal footing with the AG?
That the AG has authorized?
Absolutely. In his enabling enactment, the OSP's enabling enactment, he can prosecute with the authorization of the AG. So it's not as if it's between he and the AG, there's a split of power. The power is in the AG. So it's clear in my mind that he can't say, there seems to be, he has to acknowledge that the AG, insofar as his work is concerned, is the overall is the repository of power.
Yeah.
OSP shall be independent. OSP shall be independent. And so you see in the first line of his section 4 also, they say, he shall not be subject to the direction and control. I say, right following that, then they say that he shall prosecute on the authorization of the AG subject to Article 88. Wow. Because the AG's powers are not from the statute, from an act of parliament. They are from the Constitution. So he has overriding power. And the Constitution says that every criminal proceeding in this country shall be instituted by the Attorney General. How can an act of parliament take that away from the AG? That is not, it can't be correct. The AG is the overriding center of power insofar as criminal prosecution is concerned. And the act that establishes the OSP acknowledges it. So let's have some clarity on it, and let's have some humility in terms of power. If he acknowledges that, I'm sure he will work very well with the AG, and he doesn't have to explain to us that we're friends and we understand what we are doing. It's not what you are doing. You do what the law says you should do. Nobody cares what your relationship with him is. How this OSP from 2014 to 2015, when they said, there shall be an OSP who will make sure that all of this is dead. And we are seeing nothing. We are only seeing talk. And talk which doesn't add up, talk which is only annoying. So I told him at that time, he should shut up and do his work.